3.
Good morning, Ms. Mastura. Thank you for meeting us before the negotiation. Please have a seat. Thank you. Okay, Ms. Mastura, I'd just like to run through your objectives so that we're all aligned before me and Ms. Fatin sit down with Open Access Council later today.
Honestly, Anis, I just want this sorted out fast, but not if it makes us look weak. OpenAds using the model craft, named without our permission, has already confused so many of our clients. Even worse, that puts our brand reputation on the line. We spent years building that goodwill, so protecting it has to be our top priority.
3.
Okay, understood. To clarify, could you please outline your non-negotiables, such as the things you're not willing to compromise on?
3.
Okay, for trademark infringement, there are 3 themes, which is the first one is the immediate removal of the model craft mark from all their materials, and the second one is a written acknowledgement that model craft mark is registered to Portland Arena Sdn Bhd, and last but not least, a binding undertaking from Open Act not to use, imitate or reference from our mark in the future.
3.
Then for passing off, I have 2, which is the first one is they must stop any form of representation, whether materially, digitally or orally suggesting association or partnership with us. And second, and most importantly, our goodwill must be protected. They cannot continue any ad that would damage our standing with our key clients.
3.
Okay, now let's talk about what's open for discussion. What are you prepared to negotiate on?
Okay, for trademark infringement, I'm flexible with the timeline. 7 days for the website takedown seem fair, but I can allow up to 21 days for brochure retrieval, provided that they use genuine effort and proper documentation. And if they comply quickly and issue the written acknowledgement, I'm open to a modest settlement, something around 500,000 ringgit to close off that part.
Okay, noted. And what about for passing off?
3.
That's where the real damage lies. We have built model crafts name since 2015 with both local and international clients. My starting point for compensation is RM 700,000, but I can go as low RM 500,000 ringgit if they comply quickly with my items.
Okay, understood, Ms. Mastura. We'll lead the discussion accordingly and keep you updated right after the session.
Good. I trust you and Ms. Fatin to handle it professionally. Let's close this chapter without wasting time to go to court.
We'll do our best.
Good afternoon, Ms. Umi. I'm HANIS NASUHA, and this is my senior associate Fatin NAJWA from Melbourne and Co. As you know, we represent Portland Arena Sdn Bhd in the modular craft trademark suit.
Glad to be here. I'm Amin, acting on behalf of the Open Access Sdn Bhd from the Bureau and Partners. Thank you for agreeing to this meeting. My client couldn't be here today, but they have asked me to negotiate on their behalf toward an out-of-court settlement.
No worries, Ms. Umi. Our client also sends their regards as the company representative currently is in a board meeting. Regardless, they will make some important demands should this negotiation lead anywhere. Just like your client, our client is also keen to settle things quickly, as the longer this matter drags out, the more the company's goodwill would suffer. So let's proceed.
Alright, before we begin, let me emphasize that this negotiation is strictly private and confidential upon the parties involved. Nothing discussed here will be disclosed externally. And also, please don't worry about the minor details, as we will be handling the note-taking on our side. With that, it's important to clarify our position. Your client, Open Apps, has continued to use the model craft mark on both its product brochure and also on the website, which is, in our view, is clearly amounts to the trademark infringement.
As I mentioned on the phone, Open Apps acknowledged that the modular craft trademark appears on their website and brochure. However, they maintain that the usage was solely for the demonstration purposes to potential buyers, and there was no intent to mislead anyone.
Ms. Umi, we appreciate that context, but the fact remains that the mark is still being used without any reference to the Portland Arena, let alone any consent given to them. The public, including MINDEF tender evaluators, could easily be misled into thinking that open apps owns the product.
But my client is insistent that their intention was never to mislead. The image were minimally cropped, mostly removing sensitive content like the military personnel.
That may be, but when you put both marks to each other, it's evident that the average person would think that they are the same brands. Whether or not, according to you, military elements were removed, the trademark itself was left intact without acknowledgement, thus creating confusion for prospective buyers.
Moreover, any claim that the website designer removed Portland's Arena's credit is irrelevant. The designer is your client's agent. Responsibility for the content is remain fully with the open.
I understand. We do not wish to escalate this matter to litigation. Our client is willing to remove the mark of the brochure and website, but we need time to ensure this is done correctly.
Okay, we can accept a reasonable timeline, but it must be strictly adhered to. So, Ms. Fatin, do you have any thoughts on that?
I think that 7 days should be sufficient for open apps to remove the content from their website and retrieve brochure from the circulation.
I can contact my client immediately to remove the mark from the website, so 7 days is doable. However, the brochure may take some time since my client has distributed among the 1,500 copies to potential partners to the tender evaluators and its subsidiary office. So retrieving them all within a week might not be realistic.
Well, your client should cease any further distribution of these brochures effective immediately. However, for the ones already out there, our client would accept a formal circular or clarification notice sent to the same recipients, one that makes clear that modular craft is the property of Fatin Arena and not open apps.
That sounds reasonable. My client can issue an electronic notice to the relevant recipients within the time frame that clarified as such.
Okay, that would suffice, right? But also for the physical brochures that we mentioned, your client should also proceed with a phased retrieval, perhaps within 21 days, provided that the written notice goes out immediately and the retrieval process is properly documented. Also, we request a written undertaking that open apps is not to use, imitate, or reference or mark in the future if applicable.
That sounds fair. I will convey that to my client.
Very good. That said, Portland Arena believes some form of monetary compensation is appropriate. The unauthorized use of our client's trademark, particularly in material distributed to the government-linked entity, has caused reputational harm and confusion in the market.
My client has no intention of dragging this to trial if we can find fair terms. So may I ask what amount your client has in mind?
Alright, after reviewing the extent of use that feature our client's trademark, without any attribution, Portland Arena is seeking 500,000 ringgit as one-off-time settlement.
I appreciate that perspective, but my client is prepared to offer 300,000 as a good faith settlement, together with a full compliance on removal and return undertaking.
We appreciate the offer, but given the wide circulation and government involvement, 300,000 ringgit isn't appropriate. In the interest of closing this quickly, Portland Arena is willing to settle at 500,000 ringgit payable within 14 days of signing the settlement.
I'll have to discuss that with my client, but I believe we can agree to 500,000 ringgit with payment within 14 days, and that this amount will be treated as a full and final settlement without admission of liability.
Then, we are in agreement. The 500,000 ringgit compensation, removal of the website mark within 7 days, brochure retrieval within 21 days, and a clarification notice, and also a written undertaking to prevent the future misuse.
Okay, well, I believe I will need to get back to my client urgently to liaise our discussion today with him. I think we have some other things on our agenda that we haven't discussed, correct?
Yes, Miss Umi, we've only successfully negotiated the trademark issue. We've yet to go through the passing of matter. Perhaps tomorrow is okay with you?
Yes, tomorrow morning can come by your office around 10 a.m.
Great, Miss Umi. Thank you so much. We will be waiting at our office.
Alright, before we finalize the written terms, Ms. Umi, there's a related matter we must also address, the issue of passing off arising from the trademark infringement. Hopefully, this will not take too long of your time.
Yes, I anticipate that. So please go on.
Alright, the principle is well established and the law protects a business goodwill from being misappropriated by another that pays off as them. In the case of Reckitt and Coleman Products Limited and Gordon, the court sets out that the Trinity test, which is the existence of the goodwill, misrepresentation by the defendant and also resulting the damage to the plaintiff business. You see, Portland Arena has developed substantial goodwill since 2015 through its model craft product line, accredited by CIDB and also featured in CIDB Journal and supplied to the notable clients such as PDRM, Petronas, UMP, Perpustakaan Awam Selangor and College Politek Mara. The brand's goodwill even extend internationally with export to Melbourne and Brisbane, Australia, and it shows clearly the mark of Modulcraft has become distinctive of Portland's Arena's business. That said, your clients' use of the mark on the website and the brochures make it seems like they are passing off as our client's brand, and it has caused harm to the goodwill of the company.
We understand that position, Ms. Fatin. However, as my client has explained, there was no malicious intent. The publication was more of a demonstration error rather than deliberate deception.
The intent isn't the test, it's the effect, as cited in the case of Star Industrial Company Limited and Yap Kui Kor. Passing off arises when a misrepresentation creates an unlawful association between two businesses likely to cause confusion. By publishing the model craft mark material without any attribution and even removing Portland's Arena's name, your client made it appear as though model craft was an open source product. This is the crux of our concern. The misrepresentation has already interfered with the Portland Arena's goodwill and also the business relationship. Our client has lost several project and potential customers due to the mix-up of the brand. Its estimated cost of potential revenue loss 750,000 ringgit, but since our client is willing to settle things quickly, the claim for 500,000 ringgit is modest considering the scope of that damage and also the loss of the future client and tenders from the government.
Understood. So, given the established legal position and the clear risk of a successful passing of claim, I believe that my client will accept the RM500,000 ringgit settlement, provided that it include a clause stating that payment is without admission of liability.
That can be accommodated. What matters is that Portland Arena's ownership of Modulcraft is recognized and no further use in made of this by the open apps. Anyways, I will also need a written undertaking from your client that confirming they will stop all form of representation, whether on the product, websites, marketing material, or even verbal statement that imply any association, agency, or partnership with us. And in addition, we propose issuing a joint clarification statement to the affected client to prevent further confusion and protect both parties' credibility.
Agreed. So I will prepare the draft settlement and forward it to your office for review by next week.
Excellence. Once the agreement is signed and the compensation paid, our client will treat the matter as settled and will not pursue any further legal action. Further, as we discussed via WhatsApp prior to this negotiation, in the event of a successful out-of-court settlement, our respective clients will be bearing the cost of each of our services, correct?
Yes, that's good. And overall, this discussion went well. So thank you for the constructive discussion.
Thank you for your cooperation also, Ms. Umi, and we are glad that we have reached a mutual agreement. By this mutual agreement, we will also draft a consent judgment and send one copy for your reference and get into the e-filing system by this week.
Alright, thank you to you.